The scroll of your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
In today's video, we're diving into a fresh case from a channel I follow called Time Served, a creator who consistently delivers sharp courtroom coverage. The clip we're breaking down features yet another self-proclaimed sovereign citizen running through the usual recycled talking points while trying to dodge accountability for a trespassing charge by claiming he was too intoxicated to be held responsible. It's the same tired routine, but this one comes with an extra layer of chaos. If you're craving more courtroom breakdowns and real-world legal moments like this, definitely check out Time Served. I'll have the channel linked in the description. Now, let's get into it and see exactly how this situation unfolds.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read
Ms.
him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in
I'm
all
not a
caps,
person.
by the
I am
way.
one of the people. Thank you.
According to one of Merriam-Webster's definitions, people refers to a group of individuals, which means that if you claim to be one of the people, you're, by definition, still a person. You can twist the wording all you want, but the definition remains the same.
Okay, thank you. All right. So, for the record, that's my finding. Yeah, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held.
I've got to be straight with you. This is the first time I've ever heard someone argue that being extremely drunk somehow excuses them from responsibility. Not claiming they didn't commit the act, not arguing that the evidence is weak, but openly admitting they did it and insisting they were simply too intoxicated to face consequences. It's a bold strategy, but it doesn't make the situation any less clear.
Advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable. and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton, that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction, or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you, and let's see.
Now, will I get a moment here to articulate anything?
Don't worry, your moment will come soon enough, though it might shine about as well as a flickering light bulb. For now, let the adults handle the conversation.
I'll let you know. So sit
Appreciate
tight,
it.
I'm still working through the process.
Of course.
All right, so Ms. Sharp, it appears that the assault was not a deferral, it was a stipulated order of continuance.
That's correct, Your Honor.
All right, thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will. And Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar, is that correct?
I can neither confirm nor deny that information.
I can't confirm whether this is peak sovereign citizen logic or not. And no, I'm not a lawyer, but I did spend last night outside a Holiday Inn Express. So take that for what it's worth.
So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment. So it is never a smart thing to represent yourself, and frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel, and if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cam.
This is one of those moments where every attorney watching is probably smacking their forehead on the keyboard, because any competent lawyer, like the one sitting right beside you, would know exactly how to request discovery. That's literally their job. It's also their job to understand that Miranda warnings aren't some mandatory step before an arrest. They mainly apply to what you say after you've been taken into custody.
Represent you, you're going to have to figure all that out yourself. For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't
While we're
been
waiting.
Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged.
There were absolutely victims here. The employees and owners of that 7-Eleven you refused to leave. I'm sure they were thrilled to deal with your stubborn behavior, and I doubt it did anything positive for their business to have someone stumbling around acting as if consequences simply didn't apply.
I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
Have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was
Okay, hold
not in
on.
possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay, anything else?
That's it for now.
That was your single chance to push back against the state's recommendation to hold you on 2 $500 bonds, and you managed to do everything except argue in your own favor. That opportunity is gone now, and so are any chances of improving your situation.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taken a statement from in both questioned cases in question.
All right, so what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right, which is one of the reasons. Don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy. So
He's operating with about as much clarity as a box of worn-down crayons. Dull, unfocused, and nowhere near capable of drawing a clear thought. Every attempt he makes only smudges the picture further. And at this point, it's obvious he's not working with the sharpest tools in the box.
seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
All right, everyone, that wraps up today's video. It looks like we won't be seeing this genius again for a few weeks. But in the meantime, head over to Time Served's channel to catch more of his wild courtroom content. It's as chaotic as it gets. If you enjoyed this breakdown, hit that like button. If not, go ahead and leave a dislike. But don't forget to drop a comment with your thoughts and subscribe with notifications on so you never miss a single moment of my content.
Well, you may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. I don't know
Cool.
whether that
Well, I have
changes anything.
$100. Isn't that?
Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case, just so you know you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're gonna have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not gonna write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking
they've
of,
heard
by
you,
the way,
and Mr. Sharp has heard you, and we'll go forward that
on
way.
a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnap. I was inhumanely subject to what I would define as torturous actions. It was by CO Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal, and I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
All right, we got that.
Yep, appreciate you.
All right. Thank you. And we'll see you on the 24th.